Hey guys, welcome back to my channel. Welcome back to Real Talk Bougie, guys. Y'all, we have an update. The Tuckers, baby, it's been silent for about a month. If you keep up on the blogs or you follow Kandi on Instagram or Todd, you know a little bit about what's going on. I mean, it seems to be, after the holidays, everything has been kind of cool. They're still posting. This couple is very active on social media. So why they were trying to keep the media out of their business, baby, I don't know. Because when it's in their advantage to have us in their business, they want us there. And then right now they don't. But anyway, let's get into this. So what was filed on February 5th was Todd's response to the now infamous daddy daycare allegations. So if you recall, Kandi's lawyer on January 8th filed a document. It was the petitioner's motion for temporary hearing on parenting time and child support. This is where Kandi said things like, girl, the respondent does not pay the mortgage. You remember that. She said things like the respondent does not exercise parenting time with the minor children. He does 2 to 3 minutes chronicling his daddy daycare on social media, all of those things. Well, Todd's lawyer filed a response, okay? Almost a month later, but filed it nonetheless, okay? On February 5th, it was filed, and we're going to go, I've got them side by side, so we're going to go back and forth just to refresh y'all's memory because, baby, we can't remember everything. So I'm going to float between the two documents so we know where we're at. Okay, let's get into it. Okay, so here we go. Husband's response. Remember, this was initially it was the petitioner's motion for temporary hearing for parenting and child support. This is the husband's response to petitioner's motion for a temporary hearing on parenting time and child support. Okay. Comes now respondent T. Jermaine Tucker by and through his counsel of record, Randall Kessler and Aisha Hayward James of Kessler and Solomani, respectfully showing the court that he should be designated as primary custodial parent with primary decision-making authority until further order of the court, and files his response to petitioner's motion for a temporary hearing on parenting time and child support, and respectfully shows this court as follows. Okay. Introduction. Petitioner Kayla East Tucker, that's Kandi, okay, mother, initiated the instant action for divorce on November 25th. The parties were married on April 4th, 2014, and are the parents of two minor children, A. Tucker, born in 2016, and B. Tucker, born 2019. Okay, collectively the minor children. Okay, since the filing of this action, for a substantial period preceding, father has acted as primary custodial parent, providing the minor children with their primary day-to-day care, supervision, schooling, overall well-being, while mother's employment has required her to work out of state for extended periods. Given the nature of mother's employment, it is expected that these work-related absences will continue, making a custodial arrangement for that accounts for this reality necessary to serve the minor children's best interests. While the parties appear to be close to reaching agreement on a parenting plan and have been actively working towards resolution of issues concerning the minor children, father files this response out of an abundance of caution in consideration of the statutory deadlines to respond and to preserve his right in the event the parties are unable to resolve all remaining issues related to custody, parenting time, decision-making authority, and support. Father shows that this filing is not intended to impede settlement efforts, but rather to ensure that appropriate relief may be addressed by the court if necessary. In the event the parties are unable to resolve all remaining issues related to the minor children, Father shows that the temporary parenting plan designating him as the temporary primary physical custodian and joint legal custody, and father having final decision making authority, best promotes stability, continuity, and best interests of the minor children during the pendency of this action. Let's break that down really quick before we get into all of his answers. At the end of the day, basically, what I'm seeing is that they have alluded to that they are still in mediation. They're still trying to work this out. And even though that they may be close to working things out, the lawyer is saying he doesn't want to not file this, number one, because if he doesn't, then Kandi could win that argument, period. Okay. If someone files something, it's the other side's right and responsibility to file a response. And the lack thereof a response could be taken as no response is still a response, because no response is the other side might get that particular judgment, right? So he is responding, number one, to just weigh in. These are my answers, but also they're making note and putting it on the record that both parties are still working on talking and mediating, because we haven't heard a lot in the last month. So, number one, I'm preserving the right. I'm putting something on the record to let the judge know, kind of, hey, we're actually talking behind the scenes. And also just kind of reiterating what the matters are at hand. Okay. So that's basically what I read into that. So let's get to number one. Number one, father admits to statements contained in paragraph one. Well, what's paragraph? Girl, we read that a month ago. Nobody remembers that. So let's go over here. Number one is that the petitioner filed her petition for divorce on November 21st, 2025 in Fulton County Superior Court. And Todd says father admits to the statements in paragraph one. Okay. So number two, father admits to statements in paragraph two. Paragraph two, both parties have the two biological children. Absolutely. Nothing is contested there. Number two. Okay. Number three. What is number three? Todd says father admits in part to the statements contained in number three of the mother's motion. Let's see what the mother's motion was in number three. Minor children have significant monthly expenses that include but are not limited to nanny, childcare, tuition, extracurricular, birthday parties, medical expenses, travel expenses, maintenance, daily expenses. The respondent has failed to contribute financially to the maintenance and support the children's needs, having sole and support of the children needs, leaving the sole responsibility on the petitioner slash mother. The respondent has failed to provide financial support. So, I mean, Kandi put him out there as kind of as not helping, not keeping up the kids. And that is a problem, yet has traveled out of the country on multiple occasions on vacations without proper notification. I mean, her lawyer basically piled on. Let's see what Todd's response was. All right. So, what did Todd say to number three? Father admits in part to statements contained in paragraph three. And father admits in part the statements contained in paragraph three, the mother's motion, to the extent that parties incur routine monthly expenses on behalf of the care and maintenance of the children, including education, medical, extracurricular activities, personal maintenance expenses. Father denies all remaining allegations contained in paragraph three. Father admits in part the statement contained. So he admits in part to the statements contained in paragraph three. to the extent that parties incur routine monthly expenses. So he's admitting that, yeah, the kids do have expenses, but he's not admitting to not paying the expenses. Okay, that's number three. All right, let's get to number four. I was off track for a second. My bad, guys. Okay, so number four on Candy's side was that in the best interest of the two children for the respondent to contribute financially to the well-being and maintenance and support of the minor children on a consistent basis. And Todd's answer to number four, that the father denies the statement contained in paragraph 4 of the mother's motion to the extent that it reflects the mother's interpretation. By way of further response, the father shows that it is well settled in Georgia that it is the joint and several duty of each parent to provide for the maintenance, protection, education. So basically, I guess what Randy is saying, and I could be wrong, is that it is joint and several duty of each parent. So maybe if she is paying for certain things, I mean, at the end of the day, you're the parent and it's not just solely up to him and it's not just solely up to you, but it's each individual parent. So I don't know how they're going to work that out. I guess that's girl. Interesting. Okay. But Randy Kessler is going point for point on each one of these, that it's each person's responsibility to care for their children. And that's what they're sticking with. Okay. Number five. Number five, the respondent is a self-employed entrepreneur. They're talking about Todd at this moment, who possesses the earnings and capability and capacity to financially support two children and make financial contributions to the children's expenses. The respondent possesses multiple sources of income currently and throughout the duration of the marriage. And what did Todd say? Todd said, father admits the statements contained in paragraph 5 of the mother's motion. So, okay, yeah. Number 6, Kandi stated the respondent does not pay the mortgage or expenses at the marital residence. Now, if you guys recall, and Candy's talked about this on a couple of occasions, she purchased that home, the marital home, prior to them getting married, right? So this is Todd's answer. Just keep that in mind. Father denies the allegations contained in paragraph 6 as it is vague and ambiguous as to which residence is referenced, given that the parties jointly own multiple properties. They jointly own multiple properties. Now, Kandi might be the sole owner of the marital property, but at the end of the day, he denies the allegations contained in paragraph 6 as it is vague and ambiguous to which residence is referred. So maybe, are they saying that there's more than one marital residence? Because that would be like which. Okay, so it's basically like, okay, Kandi, which marital residence are you referring to? Because maybe they feel like there's multiple properties that are owned jointly. So we're not calling the house the house with the carriage house, the marital. I mean, this could be strategic because he might feel like or anything they own together is a marital residence. Okay, that's how he feels. I don't know. But she did not specify an address or a primary location. But she's saying that he does not pay the mortgage or expenses at the marital residence. She might know which residence she's talking about, but clearly they're not copping to anything. And he denies it because he says it's vague and ambiguous as to which residence you're referring to, given the parties jointly own multiple properties. By way of further response, father states that the parties divide expenses by agreement, which with each party responsible for expenses associated with his or her separate property, and both parties contributing to expenses related to jointly owned properties. Okay. I guess they want them to be a little bit more specific. Number 7, okay? But that was a big one because it was almost like she threw, I'm not gonna say she threw him under the bus, but it was interpreted away on the internet, about Todd. I mean, this was one that really that was one that people were like, "Okay, wait a second. Todd doesn't pay the mortgage? Oh, okay." So, I mean, it was definitely taken away, and I feel like they said it obviously for a reason, right? Okay. Number 7, the respondent does not exercise parenting time with the minor children on a significant basis despite the facade of his 2 to 3 minute social media videos chronicling his daddy daycare on his social media platforms. Okay. And to number 7, this is what Todd says. Father denies the statement contained in paragraph 7 of mother's motion. So number 7, boom, no. Okay. All right. Number 8. Kandi says, since the petitioner filed her petition for divorce, the respondent has intentionally and willfully attempted to interfere with the petitioner's parenting time with the minor children, specifically during the recent Christmas holiday. The respondent attempted to prohibit the children from traveling to New York to visit the petitioner, even though she had previously incurred costs of travel for the children to provide the respondent with significant notice of her intent to exercise parenting time during the children's designated holiday break. And to that, let's see. So that was number 8. Okay. Number 8. Father denies the statement contained in paragraph 8 of the mother's motion. Father shows that since the initiation of this action, he has been the only parent consistently present in Georgia where the minor children reside. While mother has worked out of state for an extended period of time, during this time the father has acted as the minor children's primary and day-to-day caregiver, handling their routine care, school related responsibilities, and daily needs. Notwithstanding the mother's extended absence, father has consistently facilitated mother's parenting time, including transporting minor children to New York during the Christmas holiday so that mother could exercise parenting time. Any disputes arose solely from the mother's unilateral efforts to arrange travel and parenting time without prior good faith consultation with the father, which was not in fact undetermined the minor children's best interests and undermined, excuse me. Any disputes that arose solely from the mother's unilateral efforts to rearrange travel and parenting time without good faith consultation with the father, which was not and in fact undermined the minor children's best interests. Okay. Number 9. Okay. Let's go back to number 9. Number 9. Court intervention is essential to ensure that the petitioner will be able to exercise consistent and peaceful parenting time with the minor children while the divorce proceedings are pending before this honorable court. Paragraph 9, the mother's motion does not require a response from the father as it contains the mother's request for relief. To the extent that a response is necessary, father denies any implication that court intervention is required due to the father's conduct and shows that he has facilitated mother's parenting time throughout the pendency of this action. Father states that a temporary order is appropriate to provide clarity and structure consistent with the minor children's best interest and to prevent parenting time from being unilaterally dictated based on the mother's availability, work schedule, or personal convenience rather than the children's routines and needs, which father has been responsible for maintaining since the mother's extended periods of employment related absence. Boom. Okay. Um, Number 10. Okay. Number 10, petitioner requests that the court issue a temporary parenting plan that affords the parties with respective scheduled parenting time with the minor children on a temporary basis. The petitioner requests the temporary parenting plan also include a plan that addresses how the parties shall split time with the minor children during upcoming holidays and academic breaks. Number 10, Todd says, paragraph 10, the mother does not require a response from the father as it contains the mother's request for relief. To the extent the response is necessary, the father admits that the entry of a temporary parenting plan addressing parenting time, holidays, academic breaks is appropriate during the pendency of this action. And then we'll go to number 11. Number 11, the petitioner has already secured travel itineraries for the children for their upcoming spring break. Therefore, she requests that she be awarded parenting time to the minor children during their upcoming spring break during even calendar years on a temporary basis. And Todd says number 11. Okay, number 11. It says that the mother's motion does not require a response, as it contains the mother's request for relief, but father requests that mother requests relief be denied in its entirety as it is premised on the mother's unilateral attempts to dictate parenting time with the minor children without prior good faith consultation with the father and without adequate consideration of the minor children's best interests or existing custodial structure under which father has been providing the primary day-to-day care. Father further states that if the parties are unable to reach an agreement, spring break parenting time should be determined by the court-ordered temporary parenting plan and allocated in a manner consistent with the minor children's best interests rather than by unilateral scheduling decisions. Ooh, ooh, ooh. Well, okay. All right, number 12. Number 12 on Kandi's list was the petitioner requests the court schedule a hearing to address the issues of temporary child support and parenting time at the court's earliest available consideration. And to that, Todd says paragraph 12 does not require a response. Father states that these issues should be addressed at the 60-day status conference on February 19th, or the court should schedule a temporary hearing at the earliest available date in order to establish the temporary custody, parenting time, decision-making authority, and support in accordance with OCGA 1993. Okay, so this is where we go off because then Kandi's request, you can go back to that video. These are her things. This is what she requests for relief. And we went over that in a previous video. So Kandi's requests go up to number 12, right? Todd answers 1 through 12, but then continues number 13. Any allegations not specifically admitted to herein are denied. That's number 13 request. So if there's anything else they want to throw in or anything like that, he's asking that it be denied because I guess that's just what he's asking. Okay. Number 14, father recognizes mother as a loving and capable parent and supports her continued and meaningful involvement in the lives of the minor children. However, any temporary custodial arrangement must reflect the children's present reality and best interests, recognizing the father as has functioned as the minor children's primary custodial parent during the pendency of this action, while mother has been employed out of state for extended periods and given the nature of the employment is likely to continue doing so. Father shows that a temporary parenting plan designating him as the temporary primary physical custodian with joint legal custody and father having final decision making authority best promotes stability, continuity, and the best interests of the minor children during the pendency of this action. Okay, 14. And he gave her flowers, but he also stated number 14 is I'm giving you your flowers. You're a good mother. I'm not saying that you're not, even though you dragged me in your document. I'm just throwing that in. However, in the continuity of care and who's boots on the ground at this moment, he's saying it really should be him because ma'am is working out of state and based on her schedule and all of the things, like, basically he would do the best job. That's how I'm taking it. 15, father shows that the parties have been working cooperatively. So on the record, number 15, father shows that the parties have been working cooperatively towards a private resolution of all issues. They're working hard to play nice and they're working hard to keep this offline and have already participated in multiple mediation sessions, but have been unable to reach an agreement on temporary or permanent plan or on comprehensive settlement of all issues. So they're working hard, everything's on the table, still no agreement. Father shows that it is in the minor children's best interest that such an order be entered on custody, parenting time, and support during the pendency of this action. So he agrees, like, okay, let's, even though we're working hard, and I think that he's optimistic, um, if, if custody, parenting time, and support is what needs to be worked out at this moment, that, okay, father shows that the parties have been working cooperatively. Um, Father shows that it is in the minor children's best interest that such an order be entered on custody. So he's in agreement that for the children's sake, custody, parenting time, and support, yes. Okay. We need to work on an order during the pendency while this action is pending, basically. Number 16, father respectfully requests that these issues be addressed at the 60-day status conference scheduled February 19th. Okay. Especially since the parties have already attended multiple mediation sessions. And in the alternative, father requests that the court schedule a temporary hearing at the earliest available date to the matters outlined herein. Number one, mother's motion for temporary hearing on parenting time. So Kandi's motion we were going back and forth with just a moment ago, be denied. Father respectfully requests, okay, that A, mother's motion be denied, okay, to the extent that it contradicts father's request for relief. B, the Rule Nice issuing scheduling this matter be heard at the 60-day status conference on February 19th, or the court scheduling temporary hearing at the court's earliest convenience. C, that the court establish a temporary custodial arrangement in the best interest of the children, with the father being awarded legal custody, final decision-making authority, primary physical custody of the children until further order of the court. That's C. D, he is requesting that the court determine all matters related to the minor children in accordance to OCGA 1993 and 19615. And last, E, the father be granted such order and further relief as the court in its discretion deems just and proper. Respectfully submitted the 4th day of February 2026 from Randy Kessler. And again, this was filed in Fulton County Court on the 5th of February. And baby, boom. Okay. Comment down below. What do you think? I mean, I think, look, Randy Kessler or whomever prepared this document, Aisha, whomever prepared this, I like that they went point for point. They addressed each matter. Todd has, I like that, Look, Candy's document made some assertions against her soon to be ex-husband, or her estranged husband at this time, and father of her children. Kandi obviously is not happy with this situation. The lawyer who drafted this document really wanted to put it out there that Todd's not holding up his responsibilities. They used the word facade. I feel like they kind of tried to um, they want to create a particular image, and we get it, right? Now the reality of what their relationship was, I mean, they didn't really go into that, but um it looked a certain way, and people were like, well, damn, Todd's not paying bills, Todd's not keeping up the kids, all of the things. And then this, I feel like this kind of gives you the vibe of Todd seems to always be pretty laid back and chill. Now what Kandi experienced in her relationship with this man, I have no idea. But it definitely did give him an opportunity to refute the allegations and to give his side of the story, and also request what he, as the father and soon to be ex-husband, want as it relates to the children. So you guys tell me what you think below. Um and I mean, did you kind of forget that this was even going on? But yeah, they have court on the 19th, y'all. They have court on the 19th, and I wonder how it's going to go. Are they going to be kind of, is it going to be contentious, like, oh, the bloggers are here again, kind of thing? Are they going to get to the business, or are they going to be worried because the media is there? We'll see, right? Anywho, you guys let me know what you think. Comment down below. Let's get into it. I'll see you guys in the next video. If you want to talk about this further, let me know down below. And y'all, I will see you guys in the next video. Okay. Make sure, if you're new here, subscribe, set your notifications so that when I go live, post another video, do all of the things, you will be notified. See you later, guys. Bye.